What is going on, Hive? I want to say happy early Thanksgiving to everybody and thank you for tuning in. We have the custody queens being Kristen and Sam backstage along with Ron. Buckle up for tonight. Tonight's going to be a great one. It's going to be informative. We are going to lean into the Hive and answer a lot of your questions. And I just want to say, given the whole theme of Thanksgiving, from the bottom of my heart, I'm very grateful. I'm thankful for the Hive. I'm thankful for everybody that tunes in, everybody that has an open mind, everybody that's not an NPC, some fluoridated mouth breathing zombie that just goes about their life and just takes whatever these talking suits say at face value. I'm glad that a lot of us in here don't, because it's not easy to do. It's not easy to talk about, especially when you're going to go against the grain. And I just want to give a shout out to everybody in here and let everybody know how thankful and grateful I am that the YouTube Hive has turned into this. It's great. I look forward to this every evening. And, I hope you all look forward to it as well. With that being said, the last few nights with as many guests that I've been having, on the stream, I'm going quick through my intro just so that we can have as much time as possible up here with them. So I'm going to say what's up to everybody. I'm going to plug the channel, and then I'm going to bring Kristen, Sam, and Ron up here right away. So we got Crime Spy, Kimmy, UFO Dog, Red Riding Hood, HVAC Work, Delilah, Aaron R, D-Dog Wifey, Love and Other Habits, Moto Man, Lisa Marie, Bianca, Amanda B from West Virginia, Sleuther. We got Oceans 1111, Redman, Just Neo, Kathy, Caleb, Joe, the British one, Norma, the Flying Sky, UK Karen, Curious Cat. Her name's Rio, Jody Designs, Luna. Shout out to one of my mods. What's up, Critic Rick? RBF Queen, Chelsea, not Lamey Jamie, Kara. Sorry if I said that wrong, but happy Thanksgiving to you as well. Tweedledum, Nene, Growth Renewal, Sleuther Shelly, Truth and Justice, True Crime, F6S. F6S. We got Linda Vaughn. We got Kristen and Sam / their producer, Alicia, Custody Queens Off the Clock. If you guys have not followed them, here is their page. I have it up on screen right now. Anonymous Reckoning, UFO Dog, how are you doing? Where is everybody tuning in from this evening? I see Texas is in the house. Let's show Ron and Kristen and Sam how far and wide the Hive stretches. We got Texas, Kansas City, Texas, New York, Michigan, Philly, Oklahoma, Florida, Texas, Alabama, Washington, Florida, Maine, Nevada, Bama, Scotland, Australia, New Zealand, LA, Kansas City, Oregon, Washington, Texas, Michigan, the UK, Canada, or California. Wait, yeah, Canada. North Carolina, Tennessee, New York, Pennsylvania, Melbourne, Georgia. UFO Dogs in my basement. Colorado, Melbourne, North Carolina, Chicago, Florida, Virginia, Texas. Can't even keep up with all these. Maryland, another Pennsylvania, New Jersey, Ohio, Dallas, South Africa, Massachusetts, Minnesota, New York, Washington, another UK, Michigan, Kentucky, Ohio, Indiana, Europe, Nevada, Vermont, another Indiana, Pennsylvania, Canada, Rhode Island. That's awesome. That is epic. Please. Oh, I just saw Nigeria. That might be the first time that I've ever seen that. We got Newfoundland. Wow. That's awesome. And thank you to everybody that does spread the word of the hive far and wide. We are, we got quite a footprint all over the world, and that's epic. That is awesome. And thank you to everybody that does, promote this channel and tell their friends and family about it. Tomorrow at Thanksgiving dinner, do not be shy about the hive. Don't be shy about bringing the Idaho 4 up either. Let them know that the mainstream media has brainwashed them. And real quick before, like I said, I'm going to get the custody queens and Ron up here very quickly tonight. If you have not hit that like button, guys, please go ahead and do that. We got about 160 likes, 400 people in here as we are just getting started. Please go ahead, tap that like button. Don't make me say the corny joke of please go and leave more touch DNA on that like button than Brian Koberger left on the sheath. I've said it too many times. Way too many times. But yeah, hit that like button. Please subscribe if you have not to the Hive. And the Hive Mind store went live earlier this week on Sunday. I will continue to give more details on the giveaway. I know Dana, you sent me a text. If you're watching, I did not have time to make the slide, but just know if you buy something from now until Cyber Monday, you will have a chance to win some sort of, giveaway gift. We're going to pick 3 people, and I will dial that in. If I don't talk about it on stream, I will have a post about it on all my socials. But HiveMindStore.com is now up and running. The grand opening was Sunday. All of the merch comes from our Discord. And so thank you to everybody that's made that great and special and awesome. And thank you to everybody that already has placed an order. With that being said, I'm going to go ahead and I'm going to bring up, let me get this off the screen. Let me get the layout ready. I'm going to go ahead and I'm going to bring up Kristen, Ron, and
Hey.
Sam. How are you all doing?
We are doing great. And in the spirit of Thanksgiving, we just want to say, Birdie, we're so thankful for being here again and for letting the Hive sort of have us on tonight. So we're very excited for the show.
Well, I'm grateful to have you all here, and you guys have been on an absolute terror in the best way. You guys are on fire, and I'm excited to have Ron here as well. So thank you for coming back into the Hive and chatting with me. Tonight, we're going to be talking about what can Brian Koberger do with post-conviction relief, and we're also going to be talking about the WSU lawsuit that we're hearing the victims' families are now, whether it's confirmed or not, just rumored, whatever it may be. But we're going to talk about that potential WSU lawsuit from the victims' families. And before we ask the Hive, what do we want to dive into first? Sam, Kristen, Ron, if there's any plugs that you guys want to give where people can find you, please let them know now. And I will do my best to pull them up on screen as you do so.
I just want to quickly introduce Ron. If anyone doesn't know who he is, I'm sure he doesn't need an introduction, but Ron is one of the few dual certified specialists. So he's a California family law specialist, but he's also a California appellate specialist. So for as long as I can remember, Kristen and I have been running to him with our litigation questions. And so we're so happy that he agreed to join us sort of in this true crime scene. And I'm just really excited for everyone to really meet him. I'm gonna let Kristen throw the plugs out because she's a little better at that than I am.
Ron, isn't it one of 7 that you are, or is it one of 10 with respect to all of the attorneys in California? Ron, I believe you're one of 10, correct?
Like 10, I think, 10 of us now. For a while, there was just 4 of us, but then all of a sudden a bunch of people joined?
A bunch.
Well, okay,
Six
a
more.
handful.
That's pretty freaking incredible. So you are all in for a treat. Ron is also a snake breeder. Throwing that out there if you want to buy a snake. But Ron is truly probably one of the most genuine people that Sam and I have ever had the pleasure of working with for the last decade. And he definitely goes down these rabbit holes with us.
Yeah, he's wicked smart, as you'll see quickly.
I thought I was just here as eye candy.
Me too. Right, Rod? You and I are in the same boat, huh?
Yeah. No, I've really enjoyed it. I've worked with Kristen and Sam for 10 years now, a little more than 10 years. And it's just, it's more than double, more than twice as long as I've ever worked anywhere. And it's a great firm. And I've just enjoyed knowing Kristen and Sam and working with them. And I'm really enjoying doing this stuff with them too. And it's really, really interesting to me. My wife is very excited. She is totally into true crime. I mean, she watches serial killer shows and everything. And I know she's watching right now.
Hey, Tara.
Yeah, shout out to Tara.
But no, this is really cool and really interesting. And I'm excited to be here and talk about these things.
Well, like I said, I'm stoked that you guys are here. And what we were talking about backstage is we were going to ask the Hive, type of one, do you want us to talk about Koberger's post-conviction relief first, or type of two, if you want us to talk about the WSU lawsuit first? And that's going to kind of determine what we dive into first. So 1 for post-conviction relief, 2 for the WSU rumored lawsuit. And we thought that would be a fun way to start this. A lot of ones already. Jeez. And I might not put as many comments up on the screen just because I don't want to cover Sam. Because if I do, it covers her.
That's fine. I have a big head. I'll poke through.
Sam has a size 11 shoe size.
Yeah, I'm 6 foot. Okay. I'm
And
giant.
I'm 5'2"
I was
and a half.
6 foot. Fun fact about me, I was 6 foot when I was 13.
And she'll probably just trip over one of those comments, I'm sure.
Yeah.
That's funny. Well, I saw more ones than I did two. So that is the post-conviction relief. And I think this is a good, kind of a good point for me to hand it off to you three. And from a, kind of what you guys are hearing in the legal world, if this is just a normal case, where would this be going at this point? So he pleaded guilty.
Mm-hmm.
It doesn't sound like anybody's coming to save him. The news hasn't changed. The narrative hasn't changed. Where are we at?
Okay. I guess I'll jump in on that. He's past the time to directly appeal his plea and his conviction. That was 42 days. And so that expired, I think, September 3rd. So he's now in an area where, number one, and this all assumes that he's going to be the one that does this. And frankly, I don't know that he's in a position right now where he wants to. I was surprised at the guilty plea in the first place. But he could have potentially filed a motion to withdraw his plea. That's passed. He could have... he potentially, and I think still, well, that's actually the deadline just passed to reduce his sentence. So he's into, it's called the UPCPA. Don't ask me, it's the post-conviction statute, where he can essentially, from now until September of 2026, he can challenge based on ineffective assistance of counsel. He can challenge based on it being an involuntary plea or waiver. That, I think, is potentially where, if something were to happen, if he were to make such a motion, that would probably be the ground, because I think that's what's happened here. So he's been coerced, I think, into this. He could challenge it as being an illegal sentence. I think that's a non-starter. Potentially new evidence. If it comes out that exculpatory evidence was withheld, he could potentially bring that then to the district court. This would go to Judge Hippler, but he could then appeal whatever ruling that is if that doesn't go his way.
Okay, so I'm gonna jump in, Ron, because I have a lot of questions. But one thing first and foremost, when you say ineffective counsel, what do you mean by that?
Ineffective assistance of counsel, that's something that is available to virtually every criminal defendant that has counsel. That means that essentially it's kind of like malpractice for a criminal attorney, that they did something wrong that essentially made his representation ineffective and resulted in a guilty plea or a guilty verdict. He potentially could bring that up with regard to getting into the guilty plea in the first place, and if he feels that his counsel did not appropriately represent him and did not appropriately counsel him on that.
But my question
sorry, go ahead, Tim.
I was going to say, just my question with that is, with Ann Taylor being his current counsel, does that prevent or present a potential conflict? Because
No.
Does it require her to make this argument against herself, or does he have to have the wherewithal to have the advisement from her or from another attorney?
No. In fact, if during that, for instance, during that first 42 days, he asked her to file a notice of appeal, even based on that ground, and she didn't do it, he could raise that now as an ineffective assistance of counsel. She's required to do that. And in fact, I've heard a number of defense attorneys saying that there are times they encourage their client to do that. They'll just tell them, you need to file a claim for ineffective assistance of counsel. I think it's something that's so widespread in criminal practice that I think most defense attorneys expect that's going to come at some point. And frankly, I can see why a defense attorney might use that in trying to help their client. I don't know that there's necessarily anything negative that happens to the attorney in that case. But if he asked her to do that, she would do that. And I would expect she would advocate it very strongly.
That's what I was going to ask as a follow-up question, Ron. What is it uncommon? Because my perception is it's not uncommon for the attorney that is handling the case at the trial level, or the trial court, to encourage or collaborate or work with an appellate attorney down the line to their ineffective assistance of counsel.
No, I don't think it is. And I think it could be the defense attorney would initiate the process or encourage the process. Then they'd bring in another attorney to actually pursue it. But it's generally done with the assistance and knowledge of the defense attorney, and sometimes the encouragement. So
would that be sort of like, you have like a Sixth Amendment right to have effective representation, right? So what about the part that everyone continues to talk about, like discovery? How much of a volume of discovery was really served on Ann Taylor and her inability to go through that, even though, like, if she sat 24 hours a day, 7 days a week, she wouldn't be able to do that? Would that be maybe a creative argument, or an argument that could be made that it was still ineffective counsel, just even if it was outside of her hands, because she couldn't appropriately represent him based on the discovery and things that were headed her way?
I would think that would depend on if there were other remedies that she had available to her, motions she could have filed or something like that.
Can I kind of back up from what we were just talking about and ask, why would an innocent man take a plea deal? Because I think that's really hard for a lot of like normal people to wrap their head around. And I think before, diving into these intricacies, not to completely derail it, but can you give like a simple answer? Like, why do people that are innocent take a plea deal? it's confusing to everybody, even though you can show them like stats and reasons and whatever it is, but hearing it from, I think, you three might help.
Well, let me do it from more of a practical. Birdie, if someone were to threaten someone like your wife that means the whole world to you, would you consider doing what they wanted? Because if someone did something like that to me, I would do what I had to do to make sure that my loved ones were good. And that's not even a legal analysis, but I think that is very very probable that might have happened.
Go ahead, Ron.
And I think you see it also in death penalty cases or potential death penalty cases where, you look, maybe you're in a jurisdiction where juries are much more likely to convict, or certainly not afraid to convict. You could have a judge that seems to be favoring the prosecution and what evidence is going to come in. You have you have evidence that seems pretty strong, and you have to weigh, if you're the defendant, do I want to risk the death penalty, or should I just take a plea with the promise that I wouldn't have the death penalty? It would just be life in prison.
Yeah. And just to add on to that, I mean, I think when you're looking at a courtroom venue, there's always a risk analysis about it, no matter what. Like in family law, we do it all the time. We're out in the hallway with a client. We're like, look, this is your potential settlement, or you can roll the dice. You can go to court. Maybe you have a good case, but you could still lose. And that's always present, especially when you're up against potentially the death penalty. And then I look at it like, okay, we've all sort of publicly watched the litigation that occurred up until the time of the plea. Well, what about the fact that it didn't seem like it was going his way very much, right? Like he was denied for the ability to have the alternate suspect theory. He was the judge was denying more time for the trial to go through the discovery. Like all of these things, the lack of potential confidence with Ann Taylor, like all of these potential things over days and weeks and months of your life starting to, maybe feel like, hey, I'm not going to have a quote unquote fair trial. And even if I did, do I have any chance of it actually going the way I want it to? So I think it's not that confusing that someone would take a guilty plea, especially like Ron said, you're avoiding a firing squad. And that's just on its base. You're suspending the idea that he could be pressured by someone in prison, people in prison, people outside of prison, his family, even just the pressure of his family being concerned that, Kristen said this before, his family being concerned that maybe this wouldn't go the way that he wanted to and he would get the death penalty.
Imagine his mom having a heart-to-heart with her son. I mean, they've been very quiet throughout this entire process, BK's family, but obviously we don't really know what's going on behind the scenes. But his sister showed up on the witness list for both parties. I know that his mom was being considered at some point to be on the prosecution's witness list. As a mom, couldn't you imagine her going to her son and saying, I just want you to stay alive. Whether that's, in prison or out, I've thought about that. Sam actually brought that up yesterday. And I said, that's a possibility too.
Sorry, I just can't stop talking. I've had too much coffee late in the afternoon. I just think that when you are an attorney and you're going into a courtroom and you're regularly in front of a judge and you're not going anywhere, it's going to, even if you don't want it to, even if you express all this confidence, it's going to chill your ability to feel like you can have a fair trial. And I think that does weigh heavily on it. Every time you're going to trial, you're saying, we're going to go get more time because we need to look at the discovery. We're going to go do this. And it's getting shut down and shut down and shut down over time. And the whole time your mortality is like dangling over you. And I also just think when you think about a plea, it's not necessarily a moment in time, but it's a small period of time. He could regret it right now. He could have never wanted to take it before, but during the time period that he took it, he took it. He could hate that he did that.
Right. And my question is, why do you think the narrative outpaced the evidence? Because you guys were talking about like maybe his mom is talking to him like, hey, just stay alive. But in my head, I'm like, that is the news. Technically, that should be way separate than what is going to show in trial. And in trial, there wouldn't be anything that the narrative said. So I've always been confused about that aspect of like, just stay alive. And I get it. Human influence, right? Everybody could potentially see it. The jury, the judge might. But at the end of the day, you can't, like, or maybe I shouldn't say you can't. I'll ask you, can a judge really be influenced by the news? Like for a Frank's hearing, for the DNA, for everything else, like that seems crazy to me, because I can see why people, being us, we watch the news. Well, of course, his mom's going to say, like, stay alive. But behind the closed doors, you would think they would know the evidence.
Yeah,
think.
but I think you're assuming with respect to a jury that people are going to be completely honest with respect to whether or not they've read about this case. I mean, you have to truly be living under a rock for the last 3 years to know nothing about this case. And you're also kind of making the assumption that the jury can process the jury instructions. You know, the judge is the trier of fact. So the judge is the one that's allowing or determining whether or not objections will stand or that evidence will be allowed. And he makes those rulings, but then we're leaving it up to the jury to take the information, apply it to the appropriate law and the factors. And you are rolling the dice with the jury. You could go in and present every single piece of evidence that would prove every factor of every charge, and you can still come out with a guilty plea.
Yeah, that's very true. I don't know if anyone's ever been on a jury, but someone put me on a jury. I don't know why, but after the trial, when we went to deliberate, it was horrifying how many people immediately abandoned the jury instructions. And I felt like I was corralling people back into like not making a decision as to the facts of the case or the ultimate conclusion, but like, no, we can't look at that. We can only look at this. That's what the judge said. That's what the instructions say. And I can tell you, I left that experience thinking to myself, I would never let a jury decide my fate. Never. There's so much variable.
Yeah, in my early days, I participated in some jury trials, and I know that my boss, later partner, had a trial once where they found it was a civil trial, and the jury found there was negligence, found there was liability, but they awarded $0 in damages. Afterwards, the attorneys are able to go and talk to the jurors. And the jurors came up, "Hey, congratulations! How much does your client get?" And he looked at him. He said, "Nothing. You awarded him nothing." They, even with all the instructions that were given, and I'm sure they were given very appropriate and proper instructions, they still didn't understand that when they put a 0 in that verdict form, awarding 0 damages, that the plaintiff got 0.
Yeah.
So
And that's
in a nutshell, Ron, you're saying that the jury system is flawed.
Well, I think humans are flawed.
I agree. I agree with you. It's
And all of us are flawed, and there's probably people who wouldn't want me on a jury. And it can't be perfect because people aren't perfect.
And how about just the pressure of being in a jury? How about you're like the holdout and everyone's pissed at you for being the holdout? And you're not supposed to go outside and talk to your family and have them be like, no, stay strong. You can't talk about it. You're not supposed to go online. You're not supposed to get an opinion from everyone. And everyone's looking at you saying you're wrong. And I think that there's a lot of people that are susceptible to that pressure.
Mm-hmm.
And they talked about this case. I mean, this trial could have gone for weeks, months. And they talked about whether or not they were going to put the jury members and the alternates into a hotel where they wouldn't be seeing their family. I mean, this could overlap with the holidays. There's a lot of pressure. But I just go back to, I think we talked about this on the last time we were on Birdie, is attorneys sometimes have a hard time understanding, hey, I can take this fact and I can apply it to credibility, but I cannot apply it to whether or not there was an alternate suspect, right? If attorneys and highly intellectual people have a hard time understanding that, imagine a jury saying the jury instruction is, okay, you can consider this fact, to whether or not that witness is credible, but you cannot consider this fact to whether or not he committed the crime. I mean, that's what we're asking jurors to do.
Yeah, it's mental gymnastics. And least we forget, like in this chat and in this forum, we're talking about the alternate theories, which the judge said no. So you're it's not like you're going to trial saying, hey, let's talk about the delta in time. Let's do this. Let's do that. How about these people? We're not doing any of that. We're actually not going to be able to do that. And that's got to, again, I just think that would really affect whether or not you said, you know what, I'm just going to avoid the firing squad.
This might be such a juvenile, like low IQ comment here. It might be, but in my opinion, shouldn't that all be decided by the jury? Like, I understand the role of a judge, but kind of with what you're saying, in a weird way, it's still like we've gotten away from the jury hears everything and makes their judgment to now there's these legal battles about what can the jury hear to make their judgment. And it's just ass backwards. It's so convoluted. It's so diluted that it really has stripped away what a jury of your peers is supposed to do. There's the narrative that's injected into it. You can't unring the bell. Once they hear it, you're cooked. And that's what I feel like happened in this case.
Do you want to, Ron? I feel like I'm talking a lot. Go ahead, someone.
Go ahead, Sam.
Okay.
Well, I hope that makes sense, what I was saying.
No, it's actually a very good question, Birdie.
It totally makes sense. And I think that the reason that it's hard to answer in your hypothetical is because in this case, it seems like in order for a fair trial to occur, that trial would have to occur considering all the other evidence, all the potential alternative suspects, right? But imagine a case where, you know, there are situations where the code has developed over and case law has developed over years and years and years to prevent people from having an unfair trial. It's supposed the idea behind it is gauged between based on the idea that you're going to have a fair trial. So imagine a situation where someone has been convicted of multiple murders 10 years ago, and now he's getting charged with another murder, right? It's possible that in that case, that court doesn't want anyone to be able to bring up the past murders because people on the jury would go, well, I mean, if he's done these ones, he did this one, right? And even if I'm wrong, it doesn't matter because he already committed murder. So this is a bad guy. So let's put him in jail. And that would be an inappropriate way to allow someone to have a fair trial. So I think the question becomes whether or not he actually could have a fair trial and whether the court was making the right calls or not. But the court does have discretion in deciding which evidence it's really going to allow in or not allow in. And it's supposed to be bound by the evidence code. And in this case, I totally disagree with it. I think the most persuasive evidence is his alternative suspects. But that's why I think sometimes the rules get confused where you think, okay, like then it's just like blanket not fair for anyone to have a trial. But like in a lot of senses, you wouldn't necessarily want this outside stuff in because it would prevent your client, maybe your defendant client, from having that fair trial.
Yeah, and the rules are very convoluted just because of how they come about. I mean, our system of justice came over from England. It's based on the British common law. So it's been developing and building over hundreds of years. And so you'll have a rule, you know, for instance, the legislature will make a law, and then that law is implemented. Somebody who has a really smart attorney challenges it, and they make a really intelligent criticism of the law, and a court then interprets that in this way, and then another court interprets it in another way, and then you've got conflicts in interpretation, and then the higher level court may get involved, and then maybe the legislature will get involved, and they'll change the law a little bit. And I've seen a little of the process just of changing the law. And I've been able to see some proposed changes to some California laws. And sometimes I look at it and I'm like, are you an idiot? Why are you doing that? But they always have some really convoluted reason why it's worded that way. And they're doing this and this. So there's so many, there's hundreds and thousands, tens, hundreds of thousands of people involved in developing the law. And so, yeah, it becomes a bit convoluted and complicated.
You know, again, me being the only person that's not a lawyer here, right? But talking about one of the things that I'm passionate about, which is narrative warfare and going against the narrative. I always felt like in this case, it is an attack on the Sixth Amendment, right? Okay, so you have, and I'm
Which
going
is
to
the
read
right
this.
to confront your witness.
Well, which is what? Sorry, Chris.
That's the right to confront your witness, the Sixth Amendment.
Isn't that a right to a fair trial, or is that wrong?
Wait, do I have my amendment wrong, Sam?
No, I think
I thought Sixth Amendment. Hold on.
I thought Sixth Amendment is right to a fair trial, where in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury.
Mm-hmm.
You're probably right.
Yeah,
I'm only right because I Googled it. I can
mixed
promise
up.
you off the top of my head, I could not have said that. But if the jury is poisoned beforehand by the media, okay, there has to come a point in time where do we, as the people who essentially will be the jury, and it could be us on the stand, not just in the jury, have the courts allowed media manipulation to become normal and really be an attack on that impartial jury? Because in my head, it seems like they have.
The Sixth Amendment confrontation clause is also part of that amendment.
No, yeah, and I'm sorry. I was just
I
saying.
just want to make sure. I was like,
well, yeah, you're right.
I didn't doubt you.
The right
I didn't
to
doubt
confront a
you.
witness is still in the Sixth Amendment as well.
I mean, this is an area where I think people's constitutional rights to a fair trial kind of butt heads with the freedom of the press and free speech. And that's a really difficult thing to navigate and to weigh, So, yeah, I think to some, we're in a very media heavy environment right now. And, it used to be when I was growing up, we had 3 TV channels and we had radio. Now I have an infinite number of sources I'm bombarded with in social media and television and everything, all without really a good indication of their credibility. So yeah, people and jurors are bombarded with information. I think it's impossible these days to find a juror who had never heard of or wasn't familiar with the Koberger case. And I think those who are not or who were not may not be the people you would want on a jury in the first place.
There was so much talk throughout the hearings leading up to the jury and the selection about how they were going to send out this questionnaire. And every time I listened to this, I was thinking one of 2 options. One, who the heck has not heard anything about this case? I mean, even if you lived in a remote area off the grid, I still think you probably would have heard about it on some level. And that opens the door to people not being completely honest. And then obviously that can create problems on the jury because they might have to replace a juror, or, I mean, that just opens a can of worms with respect to that. Or 2, if, like you just said, Ron, if they have not heard anything about this case, I'm a little concerned there too.
Yeah. Just to add, I think that the problem is that the media is no doubt a problem. I don't think that you can ignore that, especially in a case like this. But the concern I have is the mental gymnastics of it, right? Like, okay, we're not going to disseminate the evidence involved in this case. We're going to have a gag order in place. So because that could compromise the trial. Like, okay, fair enough. But then there's still so we're taking away the micro, but then on the macro level, there's still this narrative of here is this guilty man and we know that he's guilty. So to me, it still is a problem in the media. And I'm not saying that information couldn't have been disseminated. It's just when we say the reason we're not sharing that with the public is because of the potential, what could happen if we do that. But then we're also sharing these generic tagline stories. I think it puts everyone in this position where how could you possibly feel that it is truly fair? Even if they're trying to make it fair, it doesn't feel fair. It doesn't looks like a duck, it quacks like a duck kind of thing. And so that is just hard for me to overcome, I think, when you think about having a fair trial.
Well, they hide behind the First Amendment. That's what those people do. They will hide behind the freedom of speech, or right? That's they're going to hide behind freedom of speech, and they're going to say that there's no criminal laws that go against what we say when we put out our opinion on this defendant. Right. And then, but that also, in this case, and I'm sure there's a number, there has to be, I'd be actually very curious, like how many cases has the media manipulated somebody's trial outcome, whether it's an unbiased venue, an unbiased jury, because it's infringed on the Sixth Amendment by hiding behind the First Amendment. That's a huge issue. Why is there no federal laws that prevent the media from doing that? And I'm not saying that I want more laws at the end of the day, but there's really nothing that prevents the media from doing that, right?
Sure, but
Constitution, yeah,
right. but and a lot of it doesn't really make sense. But then you have to also consider the level of mental gymnastics that we're requiring of human beings. Like, I'm an ordinary human being, but also presumably someone that has already started going on this deep dive like myself would be disqualified from being on the jury, because I'd be like, yeah, I've, watched, 200 hours, all of which were sent by Kristen of this case, put me on the jury, coach, and they're going to be like, goodbye, we're excusing you. So I think that's an issue too, is the people that maybe are more susceptible to challenging it and looking at it from another lens may not be the cookie cutter jury in this case.
And I think, real quick, just before you guys say that, I think the freedom of the press is crucial. It's crucial. You have to have that, because in a weird way, what I just said takes away from that. So you get into this weird headbutting argument.
Oh yeah, no doubt.
We're operating in a system of justice that was conceived and designed at a time when people rode, had to ride horses, and even before the telegraph, they wrote letters that were then hand delivered. It hasn't kept up with technology, and I think at some point there are going to have to be some changes made. But at this point, it's so big and bloated that it's going to continue to be hundreds of years, I think, behind the technology and behind our society.
I agree. They wrote with candlelight and feathers, Ron, and think of how much stronger the media is. From that
even just
point,
look back at with O.J. Simpson. It was on our TV. That was it, right? If you weren't home when the news was on, you wouldn't have access to it, right? Now it's like, I bet you when I go look at my phone after the show, I'm going to have 27 notifications about something with this case from different platforms because it's in my algorithm. Like, you cannot avoid it. But I have a question for all three of you. Do you think the non-dissemination order, the gag order, do you think that was put in place? I'll start with you, Ron. Do you think it was more beneficial to the prosecution, or do you think it was actually, I know the theory of why it was put in place, but do you think, who do you think that was more beneficial to? I don't think it was very beneficial to BK at all.
No, and it certainly seems to me that the prosecution was really trying to
hide the world from the evidence. Oh, we lost Ron for a second.
I was just typing into the chat while he comes back. That wasn't like an elite question. You're right. Who did that benefit more?
I've thought about this for the last few months religiously, because I think the theory behind it was to make sure we're doing a fair trial, right? That we're abiding by the right to a fair trial. But looking at it and going backwards,
sorry,
it actually was far more beneficial. It was far more beneficial to the prosecution than it was the defense, and it actually kept us from knowing the evidence that did not support the conviction.
And who put that in place? The judge, right?
I believe Hitler put that in place.
But to me, it just seems like the cops, the state being the prosecution, and the judge, they seem to work way more hand in hand in so many different assets, like with the gag order, with what's restricted, who can say what. That just seems like those three work together way more closely than any defense attorney would ever get to work with the judge or with the police.
it's a reality of how judges are appointed, or at least from what I've seen here in California.
Yeah.
There's a huge proportion of them come from DA's office and prosecutors. They are very heavily weighted in favor of prosecution-oriented judges these days. We see that especially out here in Riverside County. Because you don't see a lot of family law attorneys, for instance, becoming judges because
we're tired, Ron.
Because we're jaded by the law.
Because of the pay cut.
But you know that they throw all of the brand new attorneys in family law, which is actually terrifying, because I can't tell you how many times the three of us have gotten a brand new judge, and it's no offense to them, but they send them to like 3 or 4 weeks of judge school, and then they put them on the bench, and then these judges are making decisions about your children. So if you actually look at it like that, it's terrifying. But they put them in family law because it's like a crash course in evidence, in separating what should be looked at and what shouldn't be. It's not a jury trial, but it's pretty terrifying how little education they get before they throw your butt on the bench.
Yeah. But so many are naturally aligned with the prosecution because they come from DA's office.
Yeah.
Well, and it just kind of almost feels like the courtroom used to be way more sacred than it is. Like, is this really a legal issue, or is this like a crisis of what the Constitution should be, because people have then fought legally to hide behind whether it's certain amendments or certain rights that they're given, right? It just feels, in my opinion, the system is simple at the face value, right? This is how it should work. But as Ron said, where they were riding horseback, riding with candles and feathers, it's just gotten very complex over all of those years.
Yeah, I think a lot of it is that everyone agrees you should have a right to a fair trial, but we haven't caught up with what exactly that looks like and how to make that happen. And I think to Ron's point about how laws are created, how common laws are created, and statutes are created in case law, and how we apply it, and it's very convoluted and confusing, and some of it conflicts. A lot of that happens because something happens in a case, there's legal precedent, and something has to get changed. I think part of the problem with this media courtroom overlap is, on the one hand, everyone agrees that like the media shouldn't be involved in a trial. On the other hand, they are. And so although they cross over, no one really acknowledges or how do we get to a point where someone comes out and goes, oh, you know what? The media did, they messed that one up. They caused that case to not be fair. Like, how does that ever come out? Because if that doesn't come out, then how do you change it? How do you prove that? How do you prove that the fact that they didn't let, they did the non-dissemination order? How do you prove that that caused BK to not take a plea that he wouldn't have taken? Or like, how do you prove that that caused him to have prejudice? I think we all sniff it and say, yeah, that's not fair. But how do you prove it? I think you have a causation issue, even though we all know. It's just, and how do you prove it?
There's so little accountability with respect to the media. I mean, I even think when Sam and I are in courtrooms, and we've been to a couple criminal cases, and obviously like TMZ or the other media are there, and it is so subjective on how they want to present what they're videoing, right? You can get a video of the defendant and he may be looking a certain way, and then you go and you run with it on the story. It's wild to me how there is such a lack of accountability. Imagine all these times, how many times has Ashley and all of these big platforms, how many times have they misrepresented the facts? And then it spreads like wildfire. And the people that are believing that have probably never sat down and objectively downloaded the documents and looked at it for themselves. They just believe. But think how many times that the injuries or the timing, think how many times it's been misrepresented.
Yeah. Don't even get me started on Ashley Banfield. I'll crash out. I can't stand it.
I thought you had a crush on her.
A crush? No. Maybe I used to. I don't know. Then she's never mind. You know what? See, this is what I'm saying, Kristen. I'm gonna go to
all right, we're gonna move on. I don't want Birdie to say anything. He's gonna have buyer's remorse over the next day.
One of the things that Sam, you made me think of when I do appeals, it's very much different than what you do at a trial level. I make a brief, the other side makes a brief, then we go argue in front of the appellate court, which is usually a panel of 3 justices. We get up, we start our arguments, and they ask me questions. And I address those questions. And I really like that. I mean, yeah, it puts me on the spot a bit, but I like that because then I have some sense of what they're thinking and what's important to them. And I can focus my argument on that. To that same end, I like it. One of the appellate courts here in Southern California will issue a tentative opinion before oral argument, so that we know exactly where they're thinking, and so that I can address that. I wish there was some better way that attorneys could interact with the jury so that they could make sure that the jurors are really understanding what they're saying, and so that they know that they're answering the jurors' questions.
Right. That's a good point. So let me ask you this. Let me ask you this, Ron. If you were starting the process of doing an appeal for BK, would you do something right now? Because I'm assuming you wouldn't want to be lapsing any of these deadlines.
Well, I would have wanted to start a month ago, probably, so that he could have all of his options. But yeah, some of the remedies he has there are potentially subject to what we call latches, which is undue delay in bringing it. But yeah, there's a lot of options that he could go through, and I would want to start. You want to start that as early as possible.
Is it kind of true, like you throw spaghetti at the wall and see what sticks a little bit? You want to try all forms of relief?
To some degree. I mean, you don't want to waste a lot of time like challenging the sentencing or challenging jurisdiction. I get really bugged when attorneys on the other side challenge things that are just, not rational. But yeah, I think you want to, and some of the federal remedies require you to exhaust your state remedies first.
And I think that what you just said, Sam, real quick, just to share this, I had a poll going before the live. Here's the results of it. And oops, where is it? Will Brian Koberger ever get out of prison? 74%. So 3 out of every 4 think that he will. And so, while yes, I understand that, nobody in here besides you guys most likely is an attorney, doesn't that kind of open, or you would think that would open other attorneys' eyes? Like, hang on, how are people who have just looked into stuff on the internet that aren't privy to the redacted info, to the secret evidence, they already think this? And unless there's some big bombshell that's still sealed, right, you would think this is something.
Yeah, I think it all comes down to his motivation. Is
Brian's?
Why did he plead guilty in the first place? Because if whatever forces are at work that require that ended up in that, most of these remedies have to be initiated by him, and if they're still in place, he's not going to pursue them for one reason or another.
But see, I guess that's my concern, is unless Ann Taylor is normally doing her own appeals, does he understand what ineffective assistance of counsel is? Does he understand that he's missing those deadlines? And what if he doesn't?
Yeah. I think it is her responsibilities as a defense attorney to make sure he's aware of those. Yeah. But just, the fact that he pled guilty on this, at least what I've seen, a pretty flimsy case, suggests that there's something deeper to this.
Well, 2 things. Kristen, if you wanted to go off that, go ahead. I was going to ask a separate question. So if you had something, Kristen, go for it. I can't hear her.
Kristen, you're mute. A sentence I never thought I'd ever say.
Well, let me ask you this while she's figuring that out then. My question to you is
I
like,
don't know.
Oh, I think it started working.
Did it start working?
Yeah.
Yep.
Okay, that would make sense because I was trying to say something earlier and I was like, wow, no one hears me. No, I was just going to say, Birdie, you had another attorney that popped up in the comments that's here. I think it was Claude Jones, something, Claude Jones Law, CLA Jones. And I would love to know your opinion, Miss Jones. So let us know. I just wanted to give another shout out to the attorney.
yeah, I think that's great. I think the more attorneys that can come out and say this, I think I actually told you, or at least you, Ron, like, well, yes, I might know about the law or the amendments. Like when I say no, even though I'm known as the conspiracy guy, I'm not an idiot. Like I understand like the Constitution and amendments, and I look into this. I might, let my brain go in random directions, but there is a credibility when you have, the practice that you three have behind this, saying this doesn't add up. This is flimsy. It's weird. Like, in that same breath, wouldn't every criminal that takes a plea deal after a shit, I guess, situation like Koberger just claim ineffective counsel? Like, at what point is ineffective counsel like just saying like, they said I was guilty, but I didn't do it? Like that, is it become synonymous? Because I feel like everybody must claim ineffective counsel if they don't get the result that they want.
I think it's more procedural. Ron, elaborate on that claim.
Well, I know I've seen lots of criminal appeals that are based on ineffective assistance of counsel. I think it is very common, and it's part of ensuring because in criminal cases, it's not the case in civil cases like we practice in, but in criminal cases, there's a constitutional right to counsel. And so there are protections in place and procedures in place to ensure that they receive effective representation. And so I think that's why it's such a big part of that. And yeah, I think you see a lot of it. I see, when I go to argue an appeal, usually there's at least 4 or 5 criminal cases on the calendar to maybe 2 or 3 civil cases. And a lot of them are dealing with that sort of thing, ineffective assistance of counsel and so forth.
Can I ask you three an on the spot question? All 3 individual answers on the spot. Are you guys ready?
Okay.
How would you get Brian Koberger out of prison if you believe that he was innocent, given where he's at today? Let's just drop the hammer. What do you think you would do your first step?
So the first thing that I always do when I leave court and I lose is I walk into Ron's office. And I tell Ron, I don't know if I'm wrong, but I feel right, and here's why. And then Ron goes, okay. And then I mean, Ron has been so great today, but Ron is one of the most brilliant minds I've ever met in my whole life, and an even better person. But I think the point is that you need to pursue every potential remedy. And, so to your point, Birdie, before, when you're saying, it's great that us attorneys are in here, and I agree, but I think it's all goes back to kind of the hive mentality. Everyone brings something different to it, right? Like, I'm not going to figure out the delta in time. I'm not going to watch all these videos, and I need the assistance of someone else to do that, to make it a team and to package it together, knowing that I have to operate within the legal system, even if I disagree with it.
Right.
So
you know the legal system, right? Let us go down all the crazy rabbit holes. Right. And then if there's something, we just tell you and you figure out legally how to do it.
Toss it to us. Kristen and I will go to Ron.
Yes.
We'll get this thing done.
Well, what I would do, yes. And you guys, the Hive is brilliant. And no, you don't have to be an attorney to understand that there's holes in this. I would like to ask, say, just a random number of attorneys who have objectively looked at this case and understand how you have to apply the facts to the law and all the procedural issues. I would like to see what that poll would look like of whether or not that this conviction doesn't match the evidence. And I think a lot of attorneys have this is something we looked at when we started the show, was there is hardly any attorneys speaking out about this, whether it's they don't want to ruin their reputation or whether they just don't want the social media, potential harassment. But for whatever reason, there's not a lot of attorneys who speak about this. And I think the more that do, the better. But no, what I would do, and Sam would probably be my bodyguard because she's known to do that. Sometimes I am too trusting for my own good, but I would get a team of 100 private investigators, the best in the business. I'd go hire Freedom Barbie, who's one of my favorite investigators, and I would find someone that hasn't spoken up, that knows something, that has exculpatory evidence, that was not available at the time because whatever reason that they didn't feel comfortable, they were threatened, they were scared, and I would find one person to break.
So like a whistleblower, essentially.
Yeah.
I've always said, or not always, as of late, there was a comment on one of my videos that said, stop raising money for Brian for legal funds. Raise money for a whistleblower. That in general might be the fastest way to do it.
Yeah. And I think like when everyone's going through the information that's coming out, I think there's more information out there that we haven't got yet. Like Kristen and I were watching that video with Devil's Advocate yesterday where you're just looking at the sheer amount of houses and individuals and how close everything was to King Road. But it just, to me, it's insane to think of a college town. There's probably 4 to 5 people in every house. And it's so close that there are definitely people out there that weren't properly interviewed or interviewed at all that know more. And there's got to be more out there. And who knows why we haven't been able to find it yet. But it just seems like there's a lot else out there that even if you've gone through every piece of evidence that we specifically have from the court file, there's a lot that didn't make it to the court file, either for whatever reason.
And I would go after one person that 3 years has passed, right? You've gone through the emotions. Okay. I think there's been enough time that has passed now that somebody who might have been terrified or scared or younger or whatever reason they didn't come forward. Right. Fast forward 3 years, I think that they might be in a different mindset and they might understand, hey, I have evidence that could potentially get BK out of prison for life, and also understanding the magnitude of sending someone to prison for the rest of their life that didn't commit the crime. I think there's a huge difference in the maturity from being 18 or whatever, 19. Yeah. I really need to figure out how to turn off my ringer. But I think that's a huge deal.
Yeah, I think as interesting, as fascinating, as complicated as what we see of this case is, I think the true story underlying it is far deeper, far broader, and far more interesting.
Yeah.
Again, I'm not a lawyer. In my head, what I would do is I would apply pressure, as much pressure as I could behind closed doors, with the threat of going public. The threat of, let me expose this misconduct. Let me expose what the lab for the DNA did wrong. Let me show you right here, before I take this to the news, the police that lied in the reports. And what we're going to do is we are going to renegotiate something, or we're going to go blow this wide open all over social media. But to your point earlier, while that might be an effective strategy, people have done that. If Brian doesn't want to do that, that's like the wild card. What the hell is this kid doing?
Well, is it really that wild? I mean, when you think about why would somebody be totally silent and be lapsing their appeals? Like, I think everyone kind of knows the potential answer to that because he's scared for some reason.
Could it be chess anymore at this point, in your opinion? Like, could it still be chess? Like, Ann Taylor, could this still be a chess move? You guys still think it could be?
I think it could be.
Yeah, but the problem is you let the other side get a couple extra moves in, right? Presumably
definitely playing defensive.
What if just showing the plea was coerced? Is that enough?
That might be, yeah. Yeah, and that's potential grounds both in the state and in federal habeas corpus.
Coercion, duress.
Is that better than ineffective is that better than ineffective counsel? Showing the plea was coerced or like under duress or whatever Kristen just said?
I think it's that's part of it, because it could be that part of the ineffective assistance of counsel was in allowing a coerced plea or not shielding him from that or something. But yeah, I think it could potentially be part of it, or just coercion on its own. Yeah.
Evidence tampering, lab misconduct. Where would that rank?
Exculpatory evidence, that to me is probably the biggest, the greatest potential for getting some relief, is if it comes out that there was exculpatory evidence that was withheld, or later discovered, then yeah, that potentially could be a bombshell for him.
Where my mind goes when I get fired up about this case, as I've talked to all three of you, it's like, if this is a rigged, like, I believe this is a rigged trial, or this was like he was getting bent over the barrel, shown the 50 states, right? So what do you do in a rigged system? You have to use their own rules and their own BS rulings against them. So what are that, or what are those? And that's what I think, like, from a true legal standpoint, maybe, how can we be the most effective? Well, let's use what they used against us against them times 100. And I don't know if that's just me, again, not knowing the law, but I feel like there's got to be ways to work within that confine of like, okay, you wanted to F over my client with X, Y, and Z with the media. Bet. All right, let's see your hard drives, Hippler. You creep. I don't know. That's what I would say. I would say some crazy shit like that.
Yeah,
like,
you can't really get at the judge's hard drives like that. But I like the tactic.
Whatever.
And I've used it before in an appeal. I had a case that I thought that I was arguing. I thought the appellate court was completely wrong, and I still do. And so I told the judge, I said, you know what, Judge, this decision you're making is so different from what's out there. I think you should publish this case, which means that other courts and litigants can rely on it in California. And they kind of looked at me funny. One of the reasons I did that is because I was trying to preserve for my client the right to go to the California Supreme Court, which would be much more likely to take a look at it if it was a published case. But yeah, I like the tactic of trying to use it, and that's what I was doing right there. I was using, okay, Judge, if you're so confident about your opinion, publish it.
Well, and is there any way to do all of that behind closed doors to kind of go back to like the pressure that I was saying that you're going to create for them before you go public to renegotiate a new deal? Like, hey, this can all happen behind closed doors, or is that not possible?
That's tough. And a lot of it, you see, the civil case that the families are bringing might allow them to get some more information, but that's not going to help BK. If there was something going on, some of these post judgment remedies he have allow for a limited amount of discovery. And so I think really these options he has are what you would want to do. But other than that, I think it's something like Kristen suggested, is hiring investigators to send them out, chasing down all these potential leads, and see if you can turn over a rock somewhere that has something.
That's what I would do. I think you can get someone to break after 3 years. I think that there's someone that's having a hard time living with themselves, that are having that guilt or whatever the emotions are, that potentially has some information that could really affect this case. And I would get it. And honestly, I do believe that there's a lot going on behind the scenes with the defense that we are not privy to. Remember how many times she kept saying to Hippler, I am not ready to go to trial. I have not reviewed all of the documents. I mean, she said that repeatedly. She was banging the court over the head with making that statement over and over. And I do believe prosecution intentionally served the discovery in the way they did to create more conflict and chaos, and to put red herrings out there so that Anne and her team didn't really know what they were focusing on. But I'm optimistic that I do believe that there's a lot going on behind the scenes. And Birdie, don't you remember, I think it was I think it was the change of plea hearing. There was at some point when they were announcing the change in plea that Anne was actually kind of tapping Brian's back, and there was a little bit of like smiling, like take a deep breath, like this isn't over, like we have a plan, or at least that's the way, I kind of, it looked like a little signal to him, like this isn't over.
I agree with that picture because I've shown that they're smiling at each other like there's hope. And I wonder if that was,
we're coming up with our next chess move.
yeah. And is that the end of Anne being on her heels, truly playing defense? Because in my opinion, the best defense attorneys never are defending. They're on offense the whole time. Anne was on defense the entire time. And I wonder if that smile and the end of this was really the end of the being on our heels. Let's see what they're going to say against you. They just threw us into a buzzsaw with the narrative machine and the media, and the state pulls every letter, or not every letter, every lever against you. They've ruined you. Let's see what they got. Because they gave, in my opinion, they blew their wad on Kohberger. What else could they possibly say about this guy?
Yeah.
I don't know.
Think of how many theories they've had over the last few months. I mean, they've tried everything from the incel to, using his education. I mean, they've tried everything.
But to Kristen, to your point about people and it being 3 years and people haven't talked, I think there's probably a bunch of people out there that are way too scared to talk. I think that that's true. But don't you think there's also maybe a bunch of people out there that don't know enough information to be too scared to talk, and maybe just no one was asking them questions? Because
no, I agree with that.
Interrogations I've seen are not really interrogations. I'm like, it's nails on a chalkboard watching those things. So I wonder if
it's so bad.
And even if someone's not giving this like, aha, this is exactly what happened. What if someone could give something that led you to go find something that could be an aha?
Why is anybody scared for their life if this is a lone wolf, wannabe serial killer, weirdo incel being Brian Kohberger that used to live in Pennsylvania, and he's not even from that state? That's my question. So people are like, they must be scared. Well, I'm like, I understand, because we're able to wrap our head around the narrative being false. But for other people, that they're like, that's why their family's not speaking out. They're being threatened, and they still think Brian's guilty. I'm like, that doesn't make any sense.
The only reason that they would be threatened is because they know something else. And my guess is that they were never even asked that question during the interrogation. I think they were clearing potential suspects that day, the following day. I would probably put money they didn't even ask some of these people if they were there, or if they had any information, or that they were part of it. I think the clearing of the suspects so early on and not treating everyone as a potential suspect until cleared, I think that was one of the biggest problems with the investigation, because they cleared 90 people within a short period of time and then moved on, and that pool was getting smaller and smaller and smaller.
In addition to, they had the media running cover for them. And I have to pee. I'm so sorry, but this is perfect timing, because Matt Law Attorney gave you guys a super chat on your side that says this. So maybe this is, I'll let you guys answer this and I'll be right back.
Go for it, Ron or Sam.
Yeah, there's so much misinformation out there in the media these days, and I am kind of with Matt Law. Is that your last name, or is it just Matt Law? But
it's probably his handle, Ron.
Yeah, I know.
But last name Law, and that's why he became an attorney.
It used to be, back when I was young, and there were 4 main broadcast companies, and they each had their news. I think the news journalists and the news media had a very strong sense of responsibility to the public to ensure that what they said was true and accurate. As more media came out and it became much more competitive, it's become more about clicks and more about about hot takes and emotion, that the truth sometimes takes a second seat. So I think I haven't given it a whole lot of thought, at least that specific case, but I tend to agree that I think we're at a point where there needs to be some way to bring that sense of responsibility back to the media and give people the ability to have a source of information that is accurate, because inaccuracies and fake news and false statements, I hear so often we agree to disagree on things that on whether something is true or not. I mean, I could say that, the sun's shining. Well, I agree to disagree. It's to that extent on some things. No, we're not disagreeing. I'm stating a fact and you're stating something that's false. We're not just disagreeing. I think I'm with you, Matt.
So just to add, and I might be wrong in this, so I apologize if I am, but there is my understanding that the media is not totally shielded from liability. It's a different standard, and it's a almost impossible standard to meet. And so maybe part of the solution is, overturning that case or holding them a lot more accountable. It seems like the standard has, based on new day and age, been expanded to a point that too much is allowed.
Part of what I do as an appellate attorney is we are trained and we are required to look as objectively and to present as objectively as we can our case. Even though we're advocating for one side, we have to present to the court if there are cases that go against us. We have to acknowledge those and argue why the court should rule in our favor on that or with our interpretation of the case. And so it's an inherent part of what I've been doing for 30 years now, is challenging my own premises, my own arguments. And I think we could use more of that out in both the legal world and the media. People are so afraid to have their positions and their opinions challenged. I think that's the only way you can ensure that it is an honest and accurate and reasonable opinion, is to challenge it.
Right. And that's where I wonder, is it as simple as saying, in here, Mr. James Patterson's book, are there points where they say he was fleeing the scene that are not in a police report, or the DNA was found here that is not listed in a court document? That should be enough.
I agree. Every time that they say that he drove back to the crime scene the next day, and we have not seen a single piece of evidence that supports that he was anywhere near like the immediate vicinity of King Road, I think there's way too much freedom, and there is not enough regulation with respect to what the media puts out. And I don't think there's any consequences. I mean, I go back to that. Ashley Banfield did one episode, and sometimes I'll just go on there and watch so I can actually get ideas and notes of how bad it is. But remember when she was reporting that Ethan was unalived in the hallway of Xana's room? And all she said was, I just should note that this is inconsistent with basically everything we've been reporting for the last 2 years.
No, Ashley, one is a fact. Yeah, Ashley, let me just tell you something. One is a fact and one is a corporate lie. Okay? You need to be held accountable for the corporate lie that you sat there all dolled up and read the teleprompter and didn't think logically about what you probably know about this case, and you just spewed it to millions. And then you're going to say,
well, that's your jury. That's your jury.
That's your jury. And these people are too dumb to realize it, that they're spilling this and spewing this to millions. And then they're getting mad at people like us who right now, we're just talking to hundreds, thousands. Like, give me a break. You know what I mean? They're doing this.
Yeah. I would actually have a lot more respect for the media if they actually instead of, digging down and actually doubling down, I would have so much more respect if they learned that the evidence supported a different position and they actually made that evidence available as well, or that they put that story out. I actually might go, okay, that I can understand, but they're not. They know that a lot of the stuff isn't supported by the evidence that we know today that we didn't know 2 years ago, or actually they knew, but the rest of us didn't.
And I agree with that. If I had unlimited funding, I don't know if this would be an effective. What do you want to say that? Like, is this an effective strategy? I would go and I would challenge their experts with my own experts if I had unlimited funding. And then I would also use that funding to look into who they say their experts are and are they on their payroll? Because now you can totally show a bias. Given,
well, that's one of the first questions they would do on the cross. Are you being paid by so and so? And I mean, they would get their excerpt.
So that's normal.
Yeah, it is normal. Look at the Karen Reed trial. It was expert versus expert. I mean, the 90% of the trial, and I think Karen Reed had the far better experts. But it's the battle of the experts.
Yeah. I have a question for you, Ron. So say you have what you believe is evidence that would prove that Brian is innocent, and you package that up into an appeal and you send that off, and then it doesn't work. Can you then do it again later when you just have some different evidence? Like, I mean, can we keep throwing stuff at the wall, or at some point are you barred from doing it? Obviously you don't want to lose credibility doing it, but at what point do you actually get to kind of make the assessment where you go, well, why don't we just try it?
Well, it depends what type of appellate or post-judgment procedure you're using. If it's a state appeal, you have to bring, you have one shot, and you have to bring all of your arguments in that one shot. And you have basically a year to do it. If you're going the federal route with habeas corpus, I suppose that if you are not successful, if you get some evidence that you think is exculpatory and you bring it to the federal court and you're unsuccessful, and then later on you get some different evidence, I think you would have to show why you were not able to present that evidence before.
Right.
But I believe, and there may be some attorneys who are a little more familiar with the habeas corpus procedure, but I think that if it's something new and different, you could then bring it. You just wouldn't be able to rely on the stuff that was argued before. Right. And you'd have to show why you were not dilatory in bringing that and why it wasn't available before.
And I'm sure
both.
I'm sure it's different also based on the state.
Yeah, well, with the federal habeas corpus, it's pretty standard across the federal jurisdictions. But yeah, every state is different too.
Would you ever, in any situation, file both appeals, like a belt and suspenders, or would you do the state one first, see what happens, and then?
I think you have to exhaust your state remedies before you go the federal route, either with the expiration of time or with making the effort.
Okay, here's a question we get often, and frankly, I would love to have you explain it. When you file the appeal, what happens? Does a panel of appellate justices review? Do you get an oral hearing? Do they deny it on the face and you don't get an oral? Walk us through that.
Yeah, and I know the California procedure. I have done federal appeals. I've done some in the 6th and the 9th Circuit a while ago, and they're relatively similar. The whole process across the board is pretty similar. You file a notice of appeal, identifying what ruling you are appealing. Then there will be some time putting the record together, and then you'll file your appellate brief. I know in California, we have a 14,000 word limit that usually comes out to somewhere between 50 and 80 pages of a brief. And then the respondent, if it's the state or the defense, usually it would be the state, they get to file one, and then the appellant can file a reply. Then when it's fully briefed, it'll be assigned to an argument panel, which is usually in, and I'm trying to remember, I think in federal, I have argued in the Sixth Circuit. I think that was also three justices. I think it's usually three. So you argue in front of a panel of three justices. In California, we get up to usually up to 15 minutes per side to argue. It's a very brief. California
15 minutes to prove your client didn't unalive 4 people. Wow.
Yeah. Sometimes if it's a complex case, you can request usually up to 30 minutes or more. But most of the criminal, actually, usually the criminal appeals that I watch, and I sit in court and watch a lot of them, are a lot shorter generally than the civil appeals. But they rule primarily on the briefs, and they'll tell us both in the training and that we get, and sometimes from the bench. Counsel, we've read the briefs. We don't want you to regurgitate your brief. Is there anything else you want to point out? That's why we get just limited time to argue. But that's an opportunity for the justices. Sometimes if they're in disagreement, they'll
is it a majority opinion or?
Yeah. So there will be 3 justices, and at least 2 have to join in the opinion. The other can write a dissent if they choose. If they're in disagreement about how it should go, they use that sometimes as an opportunity to try to bolster their side or sway a judge on the other side. And then they'll issue an opinion within usually 30 to 90 days.
Ron, are there any exhibits that are attached to the appellate brief to support the brief?
There's a record. You will designate certain pleadings, exhibits, things that were presented to the trial court. In the case of appealing a jury verdict, you'd include the exhibits, the jury instructions, and so forth. And also a reporter's transcript, which is a copy. There's a court reporter that's taken down everything verbatim as it's said. That's also put together in a reporter's transcript, and all of that goes to the appellate court.
Okay, Ron, I have a question.
Okay.
If it came out that the DoorDash order and delivery was fake,
Mm-hmm.
could that potentially, which that's one of their main witnesses, right? I think that the DoorDash driver and DM and BF, that's what kind of they're hanging their hat on. But if there was evidence to support that entire order and delivery and storyline that they had put out was fake,
Mm-hmm.
do you think that would be grounds to file an appeal?
If it's a material part of the case and it is it being false or fake would cause prejudice. That's the big bugaboo for appellate attorneys. We can prove that there was error in some way. We can prove that the judge did something wrong or that the evidence was wrong, but we also have to prove that it prejudiced the appellant. In fact, I had an appeal that came down just recently where they said, you're right, Mr. Funk. The judge was wrong in this. The judge was wrong in this. The judge made an error here. The judge made an error here. But we don't think it was prejudicial.
What about the denial of alternative theories?
Suspects, yeah.
Yeah, and I looked at a little bit at Idaho's statute on that. It seems to me that what I read of the statute and what I heard coming from the judge on that issue, I think the judge seemed a little stricter to me than the statute requires. There just has to be some factual basis for them to allege that. So yeah, that potentially could be an area where there was legal error, and if the plea was based on that, sure, potentially you could do that. In fact, legal errors made by the judge are one of the best grounds for an appeal, because then the appellate court can look at that, what we call de novo. They look at that just fresh. They don't have to give deference to the judge in that case. They can say, well, here's the evidence, here's the arguments. I don't care what the judge said. I think he was wrong. This is how it should have been. And by the way, that was prejudicial because we think a different result would have happened had the judge made the right ruling.
Birdie, correct me if I'm wrong. When they were doing the hearing about the alternate suspects, it's my understanding that Hippler, the judge, basically came down and said, there's not enough evidence for us to believe that this is a potential alternate suspect who committed the crime. And by the way, I'm not using exact words, but by the way, they didn't do it because they're all in walking distance from the King Road residence.
Well, it was essentially the reasoning that the judge gave for the alt perps not being enough was the exact same reasoning that any defense attorney would have said Brian didn't do this. Even the DNA likelihood ratio, right? Yeah. He falls right in the middle of all of them when it comes to the actual alt perps laid out. His likelihood ratio is in the middle of all of them. I put out a TikTok, a couple months ago about that, showing, the point, whatever it is. I don't remember off the top of my head, but it's crazy to me because I hear you guys talking about this and I hear this complex legal system. And in my head, while it's very interesting, I want to learn this. In my head, I'm going crazy because I'm like, why isn't anybody defending him yet? Why is nobody stepping up to get Brian Koberger out of prison right now?
Well, we don't know that nobody has stepped up. We don't know. Mm-hmm. Again, speculation, opinions, just observation. I think it is quite possible that Ann Taylor is working with some sort of appellate firm, okay, like the Innocence Project. There's a whole bunch of those, but it has to be someone with deep pockets, has to be someone with the manpower to do what needs to be done. But I believe that conversation has probably been had, and I believe that they might just be gathering all their evidence. As an attorney, I don't want the other side to know that I'm coming onto the case until I want them to know. So if a client hires me in a domestic violence case, but I need to gather all of this evidence, I'm not going to file a document that tells the world, hey, I'm representing so-and-so. So I think that there is a potential that they are in the fact gathering, that they are in the investigation process, and they are doing what they need to do, but the whole world just doesn't know about it yet.
I agree with you, Kristen. I just don't want them to be lapsed in any of those statutes of limitation.
No, I agree. I agree.
But I mean, guys, we have no blood, no fingerprints, no knife. There's no confirmed hand. There's you can't put him in the house. He didn't stalk the victims. There's no confirmed handling of the murder weapon that they never found. What are we doing? You can't see his license plate. You can't put him in the house. Sorry, Ron. Go ahead.
Oh no, I'm saying that's why he shouldn't have pled guilty.
He's an idiot. At the end, maybe not.
Maybe.
I'm sorry. Was like, that's like where my gut goes is like, if he's really just doing this, there's got to be a damn good reason. Because if this is a straight up case, right, that's not smart to do.
Yeah, no.
So Ron, what if Dylan came out and was like, it wasn't a dream. I just have a loose relationship with the truth and I'm not credible. And you should ignore everything I've said.
I don't know that necessarily would work for him because we didn't have a trial. And so we can't say that the plea was based on what Dylan said. And from what I've heard, in fact, I think Kristen said this, or maybe it was you, Sam, that Dylan was said to be the least credible witness with the grand jury. So I don't know that necessarily would help. Something that would help is, well, if someone came forward and said, no, he didn't do it, I did it. That might, that would probably help.
Yes, that would be very
Or
helpful.
if it comes out that there was blood from other people that was never turned over, or the evidence.
Like the other DNA that was the other unknown male DNA that was on I think it was the sheath, right, Birdie?
Well, there's unknown male DNA in a couple places, right?
And
like you have the handrail, you have the wall, right? And I think too, just real quick, Shoe Girl said he's not an idiot though, and obviously Shoe Girl's Dana great relationship with them. But I just want to say, you're right. He had no choice. And that's what I was kind of saying is like, if this is a straight up trial, he's going to get a fair trial. That plea deal should have never been accepted, especially given the narrative that is so locked tight around this guy. Why would the state ever, after wanting to make an example out of him, building a murder room where they press a button and this guy gets shot in a room and a firing squad, right? Why would they ever just take that off the table, given what they told us leading up to this plea happening and what they had on him? Just for them to come out and say, we can't put him in the house?
There was no smoking gun. There
That's
was
crazy.
no, I was waiting for it. I was like, please tell me and Sam that there is something that they have that we don't know about it. And it's going to be announced right now. That's going to change all of our minds, because if he didn't, then we're good with it. Right.
Again,
and
no blood.
I heard that sentencing or that plea, the change of plea was just like you say, Birdie, we can't put him in the house. We actually only have exculpatory evidence. We don't really have anything that 1000% beyond a reasonable doubt. That is the most important piece of this puzzle. Sam says it all the time, beyond a reasonable doubt.
So let me
connect the dots.
And to go off of that, just again, I'm not a lawyer. I don't know the law. No blood, no knife. Okay. The witness can't identify him, and his phone doesn't put him in the house. He never stalked them. Like, what are we doing?
Yeah.
That's crazy. Like, the fact that we're all debating, and this is not disrespectful to anybody, but I'm like, we get into this legal mess for what reason? This is crazy if you look at the evidence.
Well, I wonder if there's something more to the timing too. I mean, when you think about creating a perfect storm, you have a media frenzy while you simultaneously have a non-dissemination order that's making everyone go, he's guilty, he's guilty, he's guilty, he's guilty. Then you have some pretty good wins in court where he's going to be limited in his ability to bring forth evidence. And then right before we're actually going to go, okay, let's go to trial, and continuance is denied. Right before you're going to go to trial, maybe they're a little concerned that the evidence they have is not actually going to convict this guy. So for the first time ever, they say, you know what? Last chance, buddy. Now or never. We'll take the death penalty off the table, sign here, and this will go away because we already got you. There's probably some puffering there, you'd think.
Oh, I think you're 100% right on that, Sam.
And we also don't know exactly what the defense had versus what's coming out. It could be that some of what's coming out, the defense had. So I think that's going to be a key is as stuff comes out later on, is it something that the defense didn't have? Those are the things that you're going to look at potentially with challenging the conviction.
Well,
and isn't Ann Taylor, Birdie, isn't Ann Taylor still of the position that she didn't receive, that she's still waiting for some stuff that she either A, was entitled to automatically or that she asked through the discovery process? I believe that's still her position today.
That is still her position today. And to go off of what Ron just said is, well, and again, I'm going to back up. You're kind of alluding, in my opinion, what we're all alluding to is like, why all the secrecy if this is open and shut? And the big secret is not the secrecy if this is open and shut. The secret is that they all know it's not open and shut. And that's what's so crazy about this case. This is not straightforward. We've had thousands of documents. How many hours of audio and video does anybody see Brian Koberger shuffling around Linda Lane or the car park or anywhere on 1112? No, you don't. You look at him walking to Costco, you'd recognize that limp walk anywhere. You know what I mean? Yeah. Like, and you don't see him.
It's almost like all of the additional evidence we have, none of it points to him.
No, they put a gun to his head with the death penalty, literally.
Mm-hmm.
Pretty much.
And that's sick, dude. That's so messed up.
But he went to Costco, so he must have done it.
And they put a gag order in for narrative control around it.
Yeah. Gag orders aren't unusual, but what I'll say is, if I hid evidence or I didn't cooperate with discovery, I certainly am not going to make it easy for that to come to light later on after the case is all done.
Wouldn't you not seal stuff with a gag order, though, if your case is strong? Wouldn't you only seal it if it's weak?
Well, that's hard, right? Because there you have to circle back to the impossible mental gymnastics of not wanting all of the evidence to get out, people to be considering it that would otherwise be juries, to allow someone to have a fair trial. And by the way, it's not just the juries, it's the witnesses. Do you want your witnesses to have been able to review all of that evidence and consider it and line up their testimony? So there are legitimate ways that it can compromise a trial. I'm not saying that this is that. There is the potential for that. I think my problem is, because of the potential for that, we're all throwing it under there and saying, well, duh, this is why we haven't done it. And it doesn't always make sense in every case. It's not totally applicable.
And the gag order has been lifted. I know there's a couple comments about that, but the gag order has been lifted. And there's a couple other comments too about a special counsel. At some point, Hippler was talking about appointing a special attorney to look into the leaks. But to my understanding, Sam, Ron, correct me if I'm wrong, that never actually happened. Or maybe he appointed one and then the plea happened. But I don't really think much came of that.
Right. And I understand that we're talking, you know, in the majority of today where we are at, but the gag order to begin with, right? Like, that's just, if this is a drug hit, how many drug hits happen every weekend all over this country? Is there national security and sweeping gag orders and national attention on all of them? Not really, if ever. And it's like, why this case? Why is this case just gained momentum and steam? Why is there the drama around the leaks? Why is Amazon, Dateline, all these people putting out, you know, these series? I've always thought the weirdest thing in the world to me is that Amazon, think about how much effort they put in to prep a 3-part series on this. Lining up the interviews, scheduling them, editing it, promoting it, producing it, getting it ready to go. And Brian just so happens to plea out 2 days before their release date when they're saying that we're going to have never before heard evidence in this. That's weird. You got a book, you got Dateline, you have all these people talking. I don't get it.
Well, I think the amount of coincidences are so overwhelming that it's just like, I don't know the statistics, but I mean, how could this be possible? How could all of it be possible? And I think that that's the reason why there's so many people whom, by the way, I've never really heard from Brian or what Brian has to say. He probably has got something to say that would be pretty important to hear, that have all started to conclude that this doesn't smell right for whatever reason. I think it's hard to keep just ignoring each and every coincidence to me. There's too many in a row.
I agree. And that's where I think that I butt heads with people is my brain goes away from this is a normal case. And it actually goes to this is anything but a normal case. This is something where it's like people say, well, they can't lie in court documents. Okay, go read the 9/11 commission report. Go read JFK. They would never fudge the time. Are you kidding me? You could wipe your ass with the commission reports.
And the PCO has to be completely
family law attorneys here. How often in an average week do you have an opposing party or someone lie under the penalty of perjury?
That's what I'm saying.
Thank
you.
And if they're not lying, they are overly dramatizing it so much that you have to come to one conclusion. But I always like just putting it right back. Oh, so counsel, you were there when this happened, correct? Because that's what you're inferring.
And you're saying that could be written on paper and still be a lie.
Oh yeah, they'll have above the signature, it'll say that they're writing this under penalty. Not so much the attorneys, but the parties are saying that, which then the attorney is relaying that information. But so many attorneys almost make themselves a witness by saying this happened and this is how it went down and this is who was there. And my first question, all three of us would be like, okay, so you were there? Because clearly you are highlighting this as if you were there. And no offense, but parties lie all the time.
I may or may not have called an opposing attorney a liar from counsel table in front of the judge on more than one occasion.
Yep. Good old Ron Funk.
Yeah.
Walk out.
I have clients come to me all the time and say, she lied. What can we do? Can we hold her for perjury? And I have to tell them, look, family court people lie all the time.
And that's without national security, by the way.
Yeah. they would, the courts would be inundated with perjury cases if they prosecuted them for lying. And
You would be
it
shocked.
just, as a practical matter, and I can say this, I sometimes a couple times a month I sit as a temporary judge in Riverside County, and I had a case recently that I was the judge on. It was two people who were in pro per acting on their own without attorneys, and the question was whether the ex-husband kicked the door. And he said, no, I didn't kick the door. I did not. And then the wife says, well, I have a video here. Okay, well, let's see it. We saw it, and he's kicking the door. I'm like, dude, you lied. But honestly, that didn't really play into the decision. That it's just as a practical matter, you can't get too caught. It happens too much. And I think a lot of judges are like that. It's like, yeah, of course somebody lied. I think the important thing is that in the end, we're trying to get to the truth one way or the other. And the idea is, yeah, okay, that's a lie. That's the truth. I'm going to rule based on the truth.
Yeah. And to the point that anyone's making that people don't lie in court, like that's one of the major points of a trial. Depending on who has the burden and what you're doing, you're putting on evidence to prove your case, but you're also putting a witness on the stand, and you have a right to confront that witness. And the part of the point of that is to see if they're credible, and have the jury or the judge, depending on what type of matter you're in front of, weigh or decide whether that person lacks credibility or not. Because a lot of these things, even in a murder trial, are he said, she said. Of course, there's also evidence, but it's, no, I didn't do it. Yes, I did do it. And who is more believable? So, I think it is understandable that people think, well, no, not, the legal system, everyone tells the truth, but people lie. People lie a lot. And a lot of people lie for no reason.
And it's not even just in court. It's also in the documents. I mean, look back to the PCA. And I think at some point the prosecution even said, hey, we might have got this wrong in the PCA, but that's what we thought at the time. And of course, we didn't know what we know now back then, but that PCA was so grossly misexaggerated and littered with statements that were not true. The prosecution even said, hey, we thought that was true at the time, but yeah, it might have been a little misleading.
So I'm so glad that this just happened, because while if you show video evidence, people will say, well, that is manipulated. Yet they're going to take other video evidence and say, that's not. Then they'll look at some court documents and say, this is straight up. But then they'll say the PCA is bullshit. So what does it really come down to? If some of it written in black and white is manipulated, how can you trust any of it? If some of the video footage is manipulated, how can you trust any of it? That is the entire point of my recent theory with this Delta. And people, I don't know what it is. They lose their minds over it. It's not discrediting anybody's hard work. It's like, dude, how can we not all see this? This might have happened in a 25-minute period time frame. And the Delta makes it happen.
Yeah, I mean, and I think that if that portion, if you were allowed to enter that evidence into trial and you could get it into trial, you'd want to do that in conjunction with a forensic expert, which is testifying how long he's done this, he or she, how great he or she is, and how they know that this absolutely can happen or why it was manipulated. And then, like Kristen said, you have a battle of the experts. You have someone else say that this never happened. And so, I mean, I think it's an important fact, but I think part of lawyering and litigation requires you to authenticate the evidence and lay the foundation that essentially what you're presenting to a jury is what you say that it is. And that's true with all of the evidence that's getting presented. You're trying to get it, you're trying to make it admissible so that the jury can consider it.
It's hard enough for judges and attorneys to assess whether somebody is credible or not. That when you've got jurors who don't have nearly the training or experience that we do, then they're trying to make those assessments. You know, you fall into, how charismatic are they? Or what are their inherent prejudices? Do they tend to believe law enforcement? Do they tend to distrust law enforcement? Those things come into it a whole lot. That's why I think it's so important for law enforcement prosecutors to not let their egos get in the way of a case, but to really take seriously their responsibility to find justice. I think there are a lot of really good prosecutors and a really good law enforcement, but there's a lot of bad apples out there too, where it's ego and what can get me elected and pandering to people who want to see, somebody go down in flames.
So if to that point, I'm not just going to go off on the Delta, but I'm saying timeline now, just the timeline. Let's say this was engineered. The motivation would be for exactly what you just said. The state had to create a tight, trial safe timeline. That's what they ultimately had to do. They took the earliest, easiest, most efficient, estimated timeframes and made it work. Even if they didn't know everything, they had to do that. That is a trial safe timeline.
And they did it very early on too.
Yes, right away. And they stuck with it. Think of all of the stuff that has come out, and not once has the narrative changed. Not one time around anything. So that's my point. This was written in stone from the first press conference.
Don't deviate from it.
Yes.
Yeah, no. And I think like the idea that it would be wild to assume that evidence gets manipulated. Like, I don't know who manipulated it, but evidence gets manipulated all the time. And I mean, even in like a family law context, like people show up with text messages where they're threatening each other's life. And it's like, that text didn't exist. That was downloaded from an app. That was made up. That they changed the number on that. That happens a lot, constantly. And that's why it's so important to lay the foundation to properly authenticate your evidence before it gets in. So it's not really, I mean, listen, I'll pull out my tin foil hat too, but like, we're not even there though. You know what I mean? Like, it's not bizarre to assume that evidence could get manipulated.
Right. So when you have a PCA not add up, when you have
a 911 call that is not
911 call
transparent and is scripted.
Yes. Okay. So PCA 911 call, Linda Lane dumpster cam, Linda Lane car park, 1112 witness accounts, the movement of a cell phone, and then the physics of the actual murder. When all that doesn't add up, you don't have a crime, guys. You have a goddamn cover up. You have a cover up.
And not showing their homework with respect to the DNA.
Right. So at the end of the day, you don't have a crime. You have a cover up. You have a crime amidst a cover up. When all of that doesn't add up, again, one of the biggest things is the physics of it. Even one person killing 4 people in 25 minutes, not knowing the layout of the house with a fixed blade. Give me a break.
Yeah.
That's a Navy SEAL who's memorized the layout of a house that is highly, highly skilled and trained. To do it in silence.
We'd love to see it like an actual mock-up of that with the same build and body types of the four victims, and see if someone of the same size, frame, athletic build, if they could even do that, because I think that would be a huge issue right there.
It's like, you can't even get 10 minutes of this damn timeline to add up.
Nope.
But look at Steve G. I mean, he did a live not too long ago with the reporter room, and he's still saying that they were all sleeping when the attacks happened. It's like they are not deviating from that script, no matter what evidence comes out that disproves any of their script. It's truly wild to me.
And that ultimately is what I was just saying, where this is a trial. If it went to trial, safe timeline. It's even better of a timeline if it goes to a plea deal.
Yeah.
So Ron, if you were hired, and Ron is not certified in Idaho for anyone
But he'll
thank you.
go grab that new certification probably.
Yeah, well, Ron,
Do it.
I'm done with the tests.
But Ron, if you were working with an incredible team of appellate attorneys
Mhm.
and you had, the money to really front this case, and you had investigators and all the experts you need, what would you attack? What top 3 things would you attack in this case if you were to file an appeal?
I would probably focus a lot on the fact that the story that the plea deal was based on was inherently improbable, and I would gather up. I would gather up all the evidence that contradicts it and put that together and present it to the appellate court to show that it just based on the stuff that's coming out. And I would focus on stuff that was not necessarily available to the defense at the time, or stuff that was suppressed by the judge. And I would try to convince the appellate court that the basis for the appeal, the story given by basis for the plea deal, the story given by the prosecutor was inherently improbable based on all of this evidence that was erroneously excluded or not available or withheld.
What about, would you potentially be able to include in that anything from an expert or a forensic essentially saying that some of the evidence is not authentic?
I think you could. It wouldn't necessarily be in an appeal, but it would be in a post-judgment, one of these post-judgment procedures where you can do that. And so, yeah, I would hire the experts to analyze and show why these things that were the foundations of the prosecutor's case are just inherently improbable.
Would you go after the fact that it was represented by law enforcement that there was evidence that a cleanup crew or that a cleanup job had been done? Because I think that's a big one. And maybe I'm way off base.
I think that would be a big one, because with that, if there was evidence cleaned up, how can you really, that means it's not available to convict anyone, much less
crime scene was contaminated from day one, or from not even day one, second one.
Yeah, I mean, cops can make silly mistakes that for instance, if they had a knife, if they found a knife, but the law enforcement didn't follow the proper procedures, and that knife got excluded as evidence, that could be the whole basis for dropping a case or throwing out a plea or a verdict. Just the fruit of the poisonous tree there.
What about the body cam footage showing that the crime scene essentially wasn't immediately secured and the witnesses weren't separated? So there's someone walking around the house with a knife. Oh yeah, I set the knife over here.
Again, I've said, how is a cop not like, put your hands on your head right now? There's a guy with a knife in a house with 4 dead bodies that were just stabbed.
1000%. But no,
Yeah,
hey, let me give you a tour. Come on, guys. Let me give you a tour.
Yeah, I think in a post-judgment proceeding, habeas corpus or something, you would be able to lay all of that out and try to make your case. So yeah, I think the more contradictory information you have, particularly if you can find something that is tangible and exculpatory, in the context of all of this, it's just inherently improbable. This could not have happened as represented, and so the plea was based on an improbability or an impossibility.
Because the timeline was never meant to represent reality. It was retrofitted to get an arrest. In my humble opinion, that is what I think happened. They retrofitted the timeline to justify an arrest. Given the fact there's no murder weapon, there's only touch DNA on a sheath that, by the way, looks brand new. How is it not soaked in blood? Soaked in blood.
Wasn't it under Maddie?
It was under the blanket or under Maddie, right? Which would have been then under the blanket. And I think just between those two, how many stab wounds were there?
Well,
Like
and then there's people
100?
that'll say it was under Maddie. Technically, it was still under the bed. So that's why it's not covered in blood. I'm like, okay, but
Either way,
but what I'm saying is a stretch that maybe there's just like some manipulation happening in the timeline, right? Or maybe, I don't know. It's just, I don't get it.
That sheath is such a funny thing to me because
It's the only
you're
thing.
not the idea you're not carrying the sheath knife in your back pocket and you pull it out and do it.
How do we hold the sheath and a knife?
Secured to something. You're pulling it out and it's too convenient that was just left under the bed
And wasn't discovered initially. Let's remember that.
Yeah.
They had a guy to blame. They built this whole thing around him.
Mm-hmm.
Hence, think about this. Quadruple murder. No murder weapon. The eyewitness can't identify him. No connection to the victims. Never stalked them. No license plate. Can't see him in his car.
Mm-hmm.
No pictures or video of him going into the residence. The prosecutor says, we can't put him in the house. His cell phone doesn't put him in the house, just near the house. But 2,000 miles away, they get his father's Q-tip, and they illegally use IGG, and the FBI breaks their own guidelines to use a database that everybody spits into a tube to see if they're part Viking to match him to a quadruple homicide, and now he's facing the death penalty. Does anybody understand how dangerous this is? That's so bad.
Yeah, based on all that, of course he pled guilty, right?
Of course he pled guilty. That's my point. And it's like, dude, we're cooked. Now you got Palantir. You got Palantir pre-crime predictive behavior, which is one of the things that we were going to talk about. Maybe we didn't have time tonight. I'll have to get you guys back on again. But
then we'll do a part 2.
Yeah, no, I agree because I wish we could have gotten into the WSU funding that I said to you, Ron.
Mm-hmm.
That was kind of interesting. Your reaction when I said, well, they're saying WSU brought Brian Koberger out there to college. And I said, well, I applied to like 9 schools. And then I decided, are they bringing me out there?
Mm-hmm.
But then I told you about this funding that Koberger showed up in the middle of WSU getting millions of dollars for predictive criminal behavior. I have a new theory, if you don't mind, just to run you guys through this.
Yeah.
Koberger's papers get released. This is a stretch. This is fully speculation. But to try to make sense of it, and if you have a conspiracy mind, hopefully for people that are on your side of the stream, if they don't know who I am, just understand.
Oh, everybody knows who you are on our stream, Birdie.
Yeah, this is a tinfoil hat theory. But my thought was Koberger's writing a proposal to go into jail and interview people behind bars in like informal settings. And everybody said, well, that's why he plead. That's why he took the plea to get behind bars and interview people. But I thought, hang on, what if the argument is that Koberger was already doing that prior to this happening? What if Koberger was the one that spoiled and actually ratted out who did this by interviewing people in prisons as he was writing his paper while he was a student months before this crime occurred? So WSU had this funding for predictive criminal behavior. Koberger goes out there. He's writing a proposal to go behind bars and interview criminals about this. We see his surveys, right? And he wants to go now actually into jail. What if behind those bars in jail, he uncovered a hit on somebody's mother that had flipped on the Aryan Knights? And now Brian Koberger's taking the fall for this, and they're going to put his ass all over the media to protect him, and eventually Epstein and suicide his ass in prison, and he's in WITSEC.
I'd watch that movie.
That is a sophisticated operation.
Probably take a plea deal.
Yeah,
you know what? Plea deal too.
You know what's really interesting is that funding and that involvement of him in the predictive criminality. That could be the part of the basis for this lawsuit that is being brought against Washington State. Is they could be trying to create a duty and responsibility on Washington State and bring these murders into the zone of foreseeability through that very thing. that could be the relationship that they had with Brian and the culpability that they had.
And that's hence why we've talked about, not only is the civil suit way less of a proof of burden than the criminal suit, right?
Mm-hmm.
But WSU is essentially being sued for creating the conditions for the crime to occur. And you want to say that this is about him having him as a TA getting complaints from students? Let's go look at every other professor. How many complaints have they gotten for harsh grading or being a douchebag to somebody? What if they would have fired him and he would have went and shot the place up? Well, that's the same cause. Yeah. So are they really arguing that? And I think this is what you and I have talked about, Ron. It's that, and maybe it's like a huge sum of money for a money grab, maybe, like given civil suits, or they can't sue the federal government, but they could sue the college that accepted the federal government's funding. And that would be mind-blowing to me.
Yeah, I'm really interested to see that complaint. I'm going to keep my eyes open and take a look at that when it's made public. I'd love to see how it's pled and what theories they're advancing.
I'm very curious too, Ron, about the theories, because this is going to be, as Sam's mentioned a few times, this is going to be a big argument with respect to causation.
Yes. And I hope everybody in the Hive, I know I appreciate it. I'm sure people in the Hive and also on your channel, as this was cross-streamed, appreciated this. You guys rock. Like I said, you three, lightning in a bottle. Please do not stop. There is so much value brought to this case by having people like you all just talk in general about the law, your experience, and then we can apply it to this case. I know you guys are specifically bringing up, filings and motions in this case. And I just think it's great. I think it's awesome. I don't take it for granted. I'm grateful to have you guys here. I hope everybody has a great Thanksgiving. If you guys have any closing thoughts before we, wrap the stream up, please feel free now. But I just want to really reiterate, the Hive rocks. You guys rock, being Ron, Kristen, Sam. Thank you all. And I'll let you guys close the stream out.
Well, we wish everyone a very, very, very happy Thanksgiving as well. Hope everyone gets to spend the day with their family and just really put things into perspective of what matters and what your why is, and really how grateful you are to have what you have. That's always a day. It's my favorite holiday of the year. There's no expectations of gifts. We get to watch football, go Pack Go, this week, but we just really enjoy the day and realize, how lucky you are to get to spend that day with your family.
Kristen made me a sweater.
Yeah, I am, to add to my, my credentials, I am a DIY DIY.
That's awesome.
And I thought that fit Sam's personality.
It does. I'm a giant turkey.
And then with my bedazzle, it is a perfect mix of both of us, And I just wanted to say one more thing, and I'll let Sam and Ron take it. But there was a comment, Gary, I think it was Gary 3103 or something. I was trying to save it, but the chat goes so fast. He said he had a crush on Nancy Gray's facial expressions, and that made me laugh out loud. So I like that one.
Oh, that's rough. Sam, Ron?
Yeah, I just want to thanks to you, Birdie. This has been a lot of fun for me. And if I had the energy, I would continue for much, much longer tonight. But I hope that we can come back and spend more time with you and Kristen and Sam. I really appreciate you bringing me onto this. To the Hive, be safe. We don't want to lose any of you guys over this holiday. So just be safe, be smart, and enjoy the holiday and your families.
Well, I appreciate all three of you. And with that, Hive, and with everybody that's tuning into the Custody Queens, have a great Thanksgiving. I hope everybody gets a great night rest. And I will see you. I am going to stream tomorrow, 7 p.m. My Thanksgiving's early. Wish me luck. I'm playing in my family turkey bowl. I'm playing starting quarterback. Is that a surprise? Just kidding. All right. Anyways, that was so lame.
Ron's going to be studying for the Idaho bar exam tomorrow.
Well, good luck with that. And I hope that everybody sleeps great. And thank you to Sam, Kristen, and Ron. You guys rock. Thank you.
Right.
Cheers.